Hey, welcome to Chapter 16. We're going to be talking about law more at the international level at this point. The first learning objective talks about the principle of comity and why do the courts decide disputes involving a foreign or foreign law or judicial decree based on that principle. Well, basically it's because out of courtesy and respect, the U.S. will recognize any of these court decrees or laws of foreign countries as long as they are relatively close to what we have. For example, you would guess that anything from Great Britain or Australia we could understand. If it's a decree out of Ireland, I meant Iran, probably not. So you understand the difference. Number 2 talks about the state of active state doctrine and then when it would be applied. This simply means that the U.S., our judicial system, is not going to look into the public acts of a recognized foreign government within our own territory. So you've heard of diplomatic immunity. So, for example, that's why we see that speeding tickets or parking tickets generally are not paid by foreign diplomats here in this country. 2 terms that you might want to be familiar with, however, would be expropriation and confiscation. When the government seizes property that's privately owned for public purpose and then awards just compensation, that's expropriation, whereas confiscation is where the government will seize property because of an illegal purpose and then does not compensate that party for the confiscation. Immunity Act, and this really refers to situations in which citizens from a foreign country are subject to laws within the United States. This was enacted in 1976 and pretty specific. It says which an action may be brought in the United States against foreign nations, including attempts to take their property. There are major exceptions to this jurisdictional immunity. First off, when the foreign state waives that immunity. Secondly, when there's commercial activity involved, either within the United States or outside the United States, but has a direct effect on the United States. And then the third one is when the foreign state has committed a tort in which a government, in which certain international laws has been violated. This will be kind of interesting now because in September 2016, Congress overrode a veto by Obama in which 9/11 victims and survivors could sue a foreign country for their involvement in the 9/11 attacks. So we'll see how that works and how it affects this law. I think it probably will. Objective number 4 talks about some common clauses that are commonly included in international business contracts. And of course, I think you understand that the language between countries and legal differences can cause problems in trying to enforce international contracts. And to avoid these, then generally these types of clauses will be included. The first one would be choice of language clause. And it says basically you're going to have an agreement in that contract as to what will be the official language in case there's a disagreement. I know my brother was in the military and worked for NATO, and he said that all their meetings were always held in English. That was the international language. And then, of course, he said they go out for dinner afterwards, and all of a sudden you can hear 5, 6, 7 different languages being spoken. The second clause would be a forum selection, and that just simply means that in the international transaction, there should be, if there's any problems, indicating what court or what jurisdiction that dispute would be settled in. The choice of law clause is the next one, and that basically is if you have a problem with the contract, what law is going to take precedence. It's going to be, for example, your text talks about Germany or California or Iowa or whatever. Anyway, every international contract usually will include a choice of law clause. And the last one talks about, and I'm not sure how to pronounce it, it's French, just say force majeure clause. That's basically an act of God, and that basically says when something happens, like a natural disaster, it could also be, it could be something enacted by government too. For example, if the government ordered an embargo, then the parties would be excused from having to carry out that contract. Our law allows U.S. citizens as well as citizens of foreign countries to file civil actions in the United States court for torts that were committed overseas. So that takes away that one we're talking about with necessarily with Saudi Arabia, because the act was committed here in the United States. But anyway, in 1789, that's a long time ago, the Aliens Tort Claims Act was adopted, and that simply is going to allow foreign citizens or even foreign citizens to bring civil action in the U.S. courts for injuries caused by violations of international law or a treaty of the United States. But anyway, the law is going to allow U.S. plaintiffs to sue foreign entities. Since 1980, your text says that this has been increasing in number of citizens bringing actions against private companies in other countries. So anyway, this chapter probably has a lot of terms